as most of you know, under the previous framework, the 1995 directive, a number of adequacy decisions were taken, were adopted, that concern a number of different countries, some more exotic than others, from the Channel Islands to New Zealand. I would, if we want to get the scope, and the GDPR. The answer is in the GDPR in Article 97, paragraph 1 and 2, requires us to review the existing what the GDPR would consider existing tools for transfer. So the tools for transfers that have been adopted under the directive. As you know, we fought very much during the legislative process to ensure continuity. There's no sunset clauses in the GDPR. Tools for transfers, be it adequacy decision, SCCs, and others that were adopted under the 95 directive, continue to apply under the GDPR. But they need to be reviewed. They need to it's a sort of, if you want, health check to see if they are still complying with our system. That also reflects the general lesson. We hope that we learn our lesson from the Schrems ruling, which said the court basically told us when you're adopting an adequacy decision, you cannot just, it's a certain finding at a certain point in time, and systems evolve. Our system, the third country system, you cannot just put the decision in a drawer and wait for dust to cover it. So we need to continuously monitor it. And on the existing one, indeed, the GDPR requires us to report so to present basically a report to the Parliament and the Council by May 2020, so this is next year actually, on the existing adequacy decisions, setting aside the privacy shield, which is subject to a specific annual review. We are talking here about 11, 12 decisions. And we have started that dialogue 2 years ago almost with the concerned member third countries, asking them essentially two things. What has happened since we have adopted the adequacy decision? And some of them are back to year 2000. Think about the oldest one, Switzerland, Canada, and others. What has happened both in terms of any legislative evolution and practice, enforcement, because as you know, adequacy is not so much about law in the books, but law in practice. That was first series of questions we asked those countries. The second one concerned an aspect that, fortunately or not, we didn't have to assess before Schrems judgment, which was access by public authorities for national security purpose, law enforcement purpose. So what are the conditions, limitations, and safeguards? What is interesting is that while doing this, this is quite intense and rich dialogue, many of these countries have, for the same reason we have also embarked into a legislative reform of the data protection regime. I'm thinking about Israel, New Zealand, and others. And that, of course, is often very relevant because it strengthens the finding we may have, we made sometime long time ago. Argentina is another example. I'm mentioning it because we will be with Commissioner Jourova next week in Buenos Aires.
And we have the head of the Argentinian Commission here with us today.
I know, but that's why I'm saying it. I was on the train, but I was thinking about how to. So yes, hi to Eduardo. So that's the process we are on. We will report to Parliament and Council next spring. We hope, of course, for the continuity of this adequacy decision, but that will be, of course, assessed on a case-by-case basis in light of this evolution I've mentioned. As we know, this is not we are adequacy compared to some of the time when some of these decisions were taken is now a very, and for very good reason, a very sensitive issue in terms of scrutiny, political scrutiny, judicial scrutiny. We were talking about litigation, scrutiny by the data protection authorities, the board. We had 6 months of back and forth on the Japanese adequacy decision. So those things are not adopted lightly for very good reasons, because basically, let's also remind what adequacy is. I don't think that anybody in the UK of this community needs to be reminded that, but let's remind that adequacy means free flow of data with the EU, means assimilating in essence, a third country to a EU member states, so that data can flow freely between the EU and that third country, as it can flow freely between Spain and Austria. That requires a quite high degree of not identity but similarity, and that's what we are checking.
Okay, so thank you. So would you say that would you keep with the phrasing you used at this conference last year, that you're looking for essential equivalence rather than a carbon copy of the GDPR in the countries you're reviewing?
That's what the court wants.
Yes.
And so, yes, I want what the court wants.
Yes.
Yes.
In your heart.
In my heart, in my soul.
Yeah.
So,
Good.
yes.
Okay.
And the court, because that's very important that you remind us of, because that's a nice transition to the future adequacy. The court, because in general, and I see Andrea, sometimes even our DPA friends stop at that sentence, which is essential equivalence. And not everybody reads the sentence that comes immediately after, which says, doesn't require necessarily an identical system of protection.
Yes.
Okay. And it can be achieved through different mechanisms, through different instruments, through different means that the ones employed by the court. But
yes,
that's very important to stress.
Yes, so you're not looking for too high a level.
We are not looking for as you said, a carbon copy. This is not a point-to-point exercise. Also because systems are structured different. There are systems that, for instance, rely more on consent. That then has implication on the whole, to give an example. I'm not saying that this is good or bad, but there are systems that rely less on certain aspects of our system than on others, and that, of course, then has consequences on how the system is structured as a whole. And you need to look at a foreign system in its entirety, and to see if in its entirety it delivers a level of protection which is sufficiently similar to the one we ensure. That's the test of essential equivalence.
Okay, thank you. That's clear. Would you, in any cases, look at the way the law is working in particular sectors if they're important for that part of the economy? And I give the example in my question was, for example, financial service or banking in Switzerland. Will that be something you're looking at, or are you looking more at the high-level general law affecting citizens in general?
If it's a general adequacy that covers the whole commercial sector, and sometimes even more than that, we need, of course, to look at the whole system. But we don't have we have partial adequacy. Privacy Shield is a partial adequacy. Canada, to a certain extent, is a partial adequacy. In that case, of course, we look at the sector cover. But what also is this other important lesson of the Schrems ruling is that you cannot isolate a sector. Because since you have to look at governance access, or anyway, how data can be shared, even when you have a partial adequacy, you need to make sure that those protections of the partial adequacy, they are then carried through, that there's a continuity of protection if the data then needs to be accessed or moved, or certain continuity of protection, of course, before the reflecting all the specific needs of, for instance, governance access.
Right, okay. Now, do you do the analysis only from Brussels, or do you have analysts in each country under review who understand all the languages and the subtleties, the cultural nuance of each country?
Well, as we do for the review of your new adequacy, we rely on many sources. The first, of course, I would say port of call, we are a public institution. We are therefore our first contact is the government of the third country. Again, that's true for the review as it's true for the... But we rely on, and we have dialogues with civil society, with the business community, with academics, also to understand the broader structure. We hire consultants. We have a very, and it was extremely important, very rich dialogue with the DPAs, our DPAs, with the EDPB, which has actually, in the Japanese example, has allowed us to improve, I believe, our adequacy decision. I'm very grateful for that. And where they really test us, but that's their job. And what was interesting in the adequacy decision, they were testing us, but they were also asking questions directly to their interlocutor, which is the Japanese Data Protection Authority. So, yeah, that's it's a very, I would say, informed discussion and debate, and it has to be so, because indeed, as you say, data protection and any field, legal field, cannot be looked only in abstract. It has to be understood in all its ramification and in the broader context.
Right. Good. That's I think that's very encouraging that you engage with many stakeholders in each country. Are you looking, so you've got this target of reviewing all the current countries by May 2020, which is coming quite quickly with so many countries. And are you doing them as a group? For example, are you doing large countries first, Canada and so on, and leaving Faroe Islands till the end of the line, or how does it work?
We don't have that. For us, as you know, also representing here the EU, each country matters.
Right.
And size doesn't matter. Yeah. So
we have Commissioner for Jersey here.
Yes, they know that very well, since we have met them several times. And so we need to review all of them.
Yes. Okay. Does the European Commission, in its work, ever make recommendations? So you have various findings on the extent whether it's reaching the level or not, and do you have an action checklist at the end of the review saying we suggest that you adopt the following changes to your law to make it adequate? Like New Zealand, there were various things that weren't right, first of all, and then they spent some years changing the law, and then they did reach the adequacy standards. So will that be part of this round as well?
That's different things. While we are in the adequacy dialogue or negotiations, we might indeed, as we did, as has happened, for instance, with the Japanese, we might identify some gaps. Not all gaps, not every gap matters, of course, but certain gaps are relevant to the adequacy assessment, and there we need to find ways to bridge those gaps. And I think that was successfully done with our Japanese friends through the supplementary rules they adopted to sometimes clarify certain issues or add certain safeguards. In the past, sometimes some adequacy decisions were, I would say, adopted on a provisional basis, or meaning under the commitment that something would happen in that system. Yes. That's no longer possible today. Okay. Adequacy is a fantastic tool because it's a tool on which you can rely, and you should be able to rely as an exporter of data from the EU without any other hurdle requirements. And that's why also it's straightforward, it is cheap to use. But for that, it needs to be sustainable and solid. And with the type of scrutiny we have today, we, I think, can no longer go into the business of, yes, you're fine, but we hope that in the near future you will improve. That's no longer possible. No.
So that's, I can see how that would work for a new country which is wanting to be adequate, regarded as adequate, such as Korea, but with a country which has adequacy status, such as Canada or New Zealand. Are you thinking of probably suspending their status if there's something not quite right? You say, then we'll suspend you for 6 months until you fix various points.
Well, too early to say, and clearly our objective is to ensure as much as possible continuity. But yes. Continuity which is sustainable, right. Which therefore, meaning I cannot now exclude that we might have to take some measures, or those countries, of course, that's why we have a dialogue. The idea of a dialogue, and why we have started this 2 years ago, is to ensure that questions are identified before they become issues and problems. And we're working with those countries.
Right, okay. So how long did the Japan negotiation take? What was it like?
A bit less than 2 years, I think.
Less than 2 years, okay. And they put in quite a lot of energy, because when I was visiting the European Commission, I sometimes bumped into the Japanese delegation, and they came here with several people to meet you and so on. So they were putting a lot of it. They also
kept us busy. We kept them busy, they kept us busy.
It takes two to tango, as we could say, indeed. From Argentina.
Indeed. That's, you see?
And would you say sometimes, can you identify what's typically the easier or more difficult points to resolve, or does it depend on each case?
It depends on each case, but first it's not that we start from scratch. We have a menu, if you want. We have which is the Article 29, and then it became the EDPB adequacy referential, which has a set, which I think it's a very good document for anybody interested in the topic or any country interested, because it really says what is the core in trying to define essential equivalence. You know, there are things that are, we are not looking for portability in each and every, but we are looking for access rights. We are looking for rectification rights. So we are looking for effective enforcement through, including through data protection, an independent data protection authority or something, or similar mechanism. And that document makes very well the distinction between, I would say, the core of, in terms of essential principles, rights, safeguards, enforcement mechanisms, and what is, I would say, of secondary importance, of non-essential importance, if I can put it like this. And that's I would say, that plus the case law of the court, plus what is also said in Article 45 of the regulation, that's our benchmark, that's what we use. The Japan adequacy is an interesting one, because for the first time, it was a mutual adequacy. Yeah. That's also why it was of a certain complexity, because as countries, and that's the good news, I think, as countries are converging around similar principles that we also share, they equip themselves with similar international transfer rules. And that allows, including the possibility of having an adequacy finding. In Japanese it's called slightly differently, but that's it in essence. And which then allowed us to have this area, which is the biggest area of free flow of data in the world, because it goes both ways. Yes. Another very interesting, I think, in terms of synergies and in terms of, I would say, almost a multiplying effect of adequacy decision, is that more and more countries in the world rely on our adequacy decision to consider, when they have rules on international transfer, to consider that countries that have been considered by the EU as safe are also safe for us. So being considered adequate by the EU might also open your country to data flows from and to other third countries, and including data flows amongst third countries. I think that network effect is a very interesting one, and we are seeing this more and more. Yeah. So, but so that once again, so that system works, you need to have indeed to make sure your decisions are good ones that can pass any test.